Good afternoon, everyone. Welcome to today's webinar. My name is Pete Reed. I'm Associate Director for Program Services in the Professional Development Department at NASSP. I'll be your moderator for today's webinar. Our topic today is Student Speech 2.0, Technology, Schools, and the First Amendment. We're pleased to have with us today Dr. Suzanne Eckes, attorney and professor at Indiana University. Suzanne's a former teacher and works to prepare school leaders to face the legal challenges that frequently arise for us. Recently, I had the opportunity to attend one of Suzanne's presentations at Ignite 15. During that presentation, she engaged the audience in learning in the same area that she will address in the webinar today. During the webinar today, if you should have any technical problems, please call Rich at 703-860-7259. Rich will help you to resolve those problems. We'd also, during the webinar today, like for you to tweet your impressions of the webinar using the hashtag NASSP webinar. You can also follow NASSP on Twitter. Our handle is @NASSP. We're also on Facebook at facebook.com/principles. We'll be recording the webinar today, and it will be available on our website in the near future at www.nassp.org/webinar videos. We'll also have available to you the PowerPoint presentation that Suzanne will use during the webinar today. And now I'd like to bring in our presenter to start the webinar. Suzanne, welcome to the webinar.
Thank you. It's good to be here. Thanks so much for inviting me. I love speaking about this topic. And as Pete said, I addressed this issue at the Ignite conference in San Diego just a few weeks ago. And I feel that this is a very timely topic with a lot of litigation and current events focused on off-campus speech for students. And we'll touch upon teachers as well, if we have enough time toward the end of the webinar. So to show you that this is a real-world problem, I'm sure you all realize that this is a real-world problem when a student uses a home computer at night and writes something on Facebook that might be considered offensive to other students or school officials. But I do have a YouTube clip embedded. We practiced on the webinar earlier and we couldn't hear the sound as clearly as we liked over the webinar system, so I urge you to click on the YouTube after the presentation is over or sometime within the next week to watch this current event. It's an attorney addressing First Amendment issues on off-campus student speech. We're going to start off with a scenario. I want you to think about a 9th grade student creating a fake profile school. Let's pretend that this student is at your school, and he makes a fake profile of his science teacher using his home computer. This is not a school-issued laptop. It's completely his own home computer during his own personal time, and he posts this little profile online for the whole world to see. And the profile has a picture that he took from the school website of his teacher, and he calls his teacher a fugly biatch. So I want you to keep thinking about this and consider whether school officials can discipline the student for writing something like this from his home computer. And I'm going to give you a few more facts. Let's imagine that 7 other students like this post, and he posted it on Instagram. They like it from their home computer. And Miss Campbell walks into your office the next day and says, I want you to discipline this student who created this post. What do you do? So we've created a poll for you. And within this poll, we're interested in having you answer whether the principal can discipline this student for calling his science teacher on Instagram a fugly biatch and putting her picture up online. So just take a second and answer yes or no. Okay. It looks like 51% of you think that we can discipline this student, and 49% say no way. Well, I think I agree with the 49%, but I will preface that with one important comment. The U.S. Supreme Court has never decided a case yet on student off-campus speech within the school context. So I'm basing my opinion on the federal district court cases as well as Circuit Court of Appeals cases on the general trend that we're seeing with student off-campus speech. And so let me just walk you through what a lot of these court cases are based on. They're based on this very old 1969 case, Tinker versus Des Moines, which I'm sure you all learned about this case. The students wearing the armbands to school to protest the Vietnam War when you took your principal licensure courses, when you took your school law course. The courts are relying on this Tinker case for these off-campus speech cases, and they're arguing that in order for school officials to be able to discipline these students for their off-campus speech, like on the scenario we just covered, this speech needs to create a material and substantial disruption. There needs to be a connection back to the school and a material and substantial disruption before the student can be disciplined. Now, some of you said the student should be able to be disciplined, and of course we probably need some more facts. But the general trend is it really needs to create a substantial disruption, and you're going to see this in some real-life cases that are fairly recent that we'll review in the next few slides. So if you're in groups at your school location, I want you to discuss the scenario I'm about to pull up. And if you're alone, you can think about this on your own, how you would respond. So this is a real-life case from Pennsylvania on the next slide. So in this case, a student creates a fake internet profile from his home computer, or his grandmother's computer, and he creates this profile with all kinds of questions and answers about the principal. And I know maybe some of you will find some of these questions and answers offensive, and I can assure you I don't make these up. These are cut and pasted right out of the Third Circuit Court of Appeals legal case. So let's take a look at the next slide. This is what the student wrote on the fake profile about his principal. You know, your birthday, he's too drunk to remember his birthday. And you can read through the rest of them. I think most of you would find this, you know, problematic if a student wrote this about you, and especially if the student attached your picture to it. So after the administrators learned about this, they disciplined the student. I'm wondering if you think you would do the same thing. So we're going to pull up another poll, and based on what you know from the facts of this Third Circuit case out of Pennsylvania, tell me if you think we can discipline the student. I would argue that this speech, this off-campus speech, is a little bit more offensive than the fugly biatch. And after your vote, I'll tell you what the Third Circuit Court of Appeals said in 2011. Okay. It shows, so some of you are probably convinced after I did the last scenario, 55% of you say no. And you are right on the money, at least with the Third Circuit Court of Appeals. So I did mention that, like many of you, like 45% of you, the administration in this real case, they did discipline the student. He was suspended. He was placed in an alternative education program for the remainder of the year. He was banned from extracurricular activities, and he was prohibited from attending graduation. When I spoke about this case at Ignite 2015 in San Diego with NASSP a few weeks ago, people said, whoa, you know, they went all out in disciplining this student. We might not have done this much, but we would have disciplined him. The majority of the attendees did say that. But you'll find that the Third Circuit Court of Appeals found no evidence of disruption. They didn't feel that this speech was offensive enough. There wasn't a strong enough connection back to the school where there was a material and substantial disruption, and the school district, loses, the student is granted summary judgment in this case. So we have another case from the Third Circuit. It was decided on the same day as the one we just discussed, also out of Pennsylvania. So a student creates an internet profile of her principal. It has pretty sexually explicit content. You can Google these cases if you're a geek like me and love reading cases. If you're bored this Friday night, you can Google JS versus Blue Mountain School District and read all about what happened in this case. But I'll just give you some of the important facts. So it contained the principal's picture, but it didn't have his name or the school's name. And the student did limit access to some of her friends, where she posted this picture with a sexually explicit profile. Now, I will say it was undisputed that there was no evidence of disruption in this case, but nevertheless, this student was suspended. So Third Circuit Court of Appeals weighs in on this case as well, and the district court had it decided in favor of the school district in this case initially, but then the Third Circuit Court of Appeals reverses, and they again find that there's just not enough evidence that there was strong enough disruption, relying on the Tinker versus Des Moines case from 1969. After the Ignite conference, I put this little dislike symbol because so many of the attendees in the audience really disliked this outcome of these two Third Circuit Court of Appeals cases. So now I'm going to talk about a case that comes out of the Second Circuit Court of Appeals.
Suzanne,
And, yes.
I'd like to interrupt. We have a question, I think, that's germane to that last slide.
Oh, great. Okay.
If you can't discipline, can you press charges for defamation of character?
That's a great question. That question came up in San Diego as well, and absolutely. Now, defamation is governed by state law, so what you'd want to look at what the state statute says in your particular state about defamation. In my state here in Indiana, it needs to be untruthful for one, and most of the statutes are somewhat similar in their language, but that is certainly an avenue that either one of those principles could take. So outside of the First Amendment, there are some other legal avenues. But when the cases are focused on First Amendment, these courts are applying the Tinker decision the vast, vast majority of the time. Sometimes you see the Frazier decision referenced at least, but it's mainly the Tinker decision. And with regard to First Amendment, at least out of the Third Circuit, we have the students prevailing on the First Amendment claim. On the defamation claim, who knows what would happen. It would have to, the principal would have to show that this was, maybe the principal's a public figure or a private figure, have to differentiate between the two. But if the principal is considered a private figure in that state and this information is articulated to a third party and the third party believes it to be true, we could, I think, definitely have a viable defamation claim. So that's a great question. So we have a different result in the Second Circuit Court of Appeals, and this case occurred in Connecticut. And you can see that we have a high school student, and she blogs on her computer. She was a little angry with school administration when they were interfering with her plans to hold Jam Fest in the school auditorium. I'm a former high school French teacher, and I can absolutely imagine this happening when I used to teach. So again, a real life case. So she was pretty angry. She called school officials douchebags on her blog from her home computer. And school employees, they learned about this online post. She was prohibited from running for student council. So just imagine how this student may have responded to the school officials' reaction. So in response, kids started wearing T-shirts to school that said, "Vote for Avery for student council." This student also appeared with her mother on a local news station to discuss the matter, how they're interfering with her First Amendment rights, of course. And The district court grants summary judgment to the school district, and the Second Circuit Court of Appeals, which is Connecticut, New York, and Vermont, they upheld the district court's decision. So the school district wins in this case at this level. The court found that it was foreseeable that the student's speech created a potential risk of substantial disruption. We only have 45 minutes on this webinar and 15 minutes of questions, so I can't get into a lot of the details on this case. But if you do Google this case or read it on FindLaw, or if you have access to Lexis or Westlaw and you read these cases, you'll see that this case, I would argue, does have a little bit more evidence of disruption than the earlier two cases from the Third Circuit Court of Appeals. So again, this case is only binding Connecticut, New York, Vermont, but I still think it's an important case for all of us to know about because the U.S. Supreme Court hasn't decided a case on this particular issue yet, and so we're trying to navigate right now by following what the Circuit Court of Appeals have said about this topic. And usually when there's a, oh, go ahead, Pete.
And we do have a question.
Oh, sure, go ahead.
Do you believe the Supreme Court will weigh in on any cases like this in the near future?
Well, I was so hopeful that they would either, you know, weigh in upon either the Third Circuit case or the next case that you're going to see, because it's a 2014 case, you know, maybe they'll take that one. But so far, they've denied cert on all of these off-campus speech cases, which is a little bit troubling in my opinion, because usually when there's a split in the circuit, that's typically when the court might take a case to settle the split in the circuit. But to date so far, they haven't agreed to hear one of these off-campus speech cases. That's a great question. We've all been waiting, and so far it's just been without luck that they've taken a case. Now maybe they'll take this next case, so wait until you see what happened in the Fifth Circuit. In this Fifth Circuit case is a 2014 case. So this is binding in Louisiana, Mississippi, and Texas. So in this case, we have a high school senior. He decides to record a little rap song that he subsequently posts on Facebook and YouTube. And in his song, he mentions two high school coaches who happen to also teach at the school. And these coaches really felt intimidated and harassed by the song. And I have a couple of the lyrics on the next slide that I'll show you before we do our next poll. And you can, you know, tell me when we do the poll if you think these lyrics are particularly problematic or not. Let's see. So here's the language from the song, and I also embedded the YouTube video, or not the video, but the song. You can hear it on YouTube and hear the whole song. When I play this in front of my principal prep students who are all getting their principal license, I played this song in class a few weeks ago, they found this song highly offensive and said, absolutely, this student's going down. He has no First Amendment rights. When I play it in front of my pre-service teachers who all take law at Indiana University, we require teachers to take law, they all found it to be a catchy tune and that we should not discipline the student. Let's see what you think. Can the principal discipline this student? This is a very recent case. Okay, so 74% of you say yes. Now, quite honestly, when I was first reading this case this summer, I thought the same thing. But to my surprise, this isn't the case. So I mentioned that the principal and the superintendent, they accused this student of creating false accusations against the coaches, teachers. The student was suspended, and he was later sent to an alternative school. He sues in federal district court, and he lost at that level of court, in the federal district court, because they did find that this created a material insubstantial disruption, this rap song. But then the student appealed to the Fifth Circuit Court of Appeals. So again, just one federal court below the U.S. Supreme Court. And as soon as we get the slide back up, I'll show you what the court ruled in this particular case. They ruled that his speech was protected by the First Amendment because this was recorded off campus using his home computer. They kind of took the same approach as the Third Circuit Court of Appeals. So we have the Third Circuit and the Fifth Circuit granting, I would say, greater freedoms to students' First Amendment rights when it's totally off campus, with the Second Circuit taking a slightly different take. When you read these whole decisions, it's kind of like, school officials, buck up, you need to have thick skin. Students are going to criticize you, whether you agree with that or not. That's kind of the approach that's been taken, at least in these few circuits. They didn't find that it created substantial disruption. Again, they relied on the Tinker case, and they found the lyrics to be rhetorical, that they couldn't be viewed as a serious threat, even though it discussed a pistol. And I will tell you this. Just last week, after I submitted this PowerPoint to NASSP, I subscribed to the National School Boards Association legal clips, and maybe some of you do too. They give you free email every Thursday of a lot of the cases that are either being heard or brewing in the U.S., and this case was on there, and the Fifth Circuit Court of Appeals agreed to rehear this case last week, and they agreed to rehear it en banc, which means the whole panel of Fifth Circuit judges will rehear this case. When it was initially heard at the Fifth Circuit Court of Appeals, only 3 judges heard the case. So now it'll be heard again. And so we never know. It might be reversed, like 74% of you agree that the student should be disciplined. I would think it will be overturned, but I have known to be, been wrong before in the past, so we'll see what happens with this Fifth Circuit en banc decision. So let's all pay attention to court cases in the news and watch in the next 6 or 7 months what happens with this particular case. Now we're going to switch gears to speech that harasses students. You'll notice that the first few cases that we covered dealt with student speech that really harassed principals or teachers. Now what about off-campus speech that targets other students? I know 49 states right now have anti-bullying laws in place. Some of those laws have more teeth than others, but I would argue that you have a duty to address harassment, peer sexual harassment under Title IX, even under general negligence theory. And so let's see what happens when students harass other students from their home computer with no connection to the school when it initially occurs. And we had this in West Virginia. A high school student creates a web page from home about a classmate who has herpes and was a slut. She invited others to comment on the web page, and it also included photos of the student. So this case is Fourth Circuit, Maryland, North Carolina, South Carolina, Virginia, West Virginia, and the Fourth Circuit Court of Appeals upholds the district court's decision, and they find in favor of the school district. I wasn't shocked by this. I think there is a difference between when students, at least courts are seeing there's a difference between speech that's harassing students versus speech that is harassing students off campus. So there's one example of this West Virginia case that eventually went to the Fourth Circuit Court of Appeals. What about online speech that involves threats? So in 2013, we have a Nevada high school student. I'm going to go through these fairly quickly because I think they're pretty easy. A Nevada high school student wrote from his home computer he would commit a school shooting. This student, he specifically named classmates. He identified the school. If you read the case, it's pretty obvious what he had in mind. He also notes that he has access to weapons and to other forms of ammunition. So I don't think any of you will be surprised by this outcome. He was eventually expelled for 90 days. It goes to the Ninth Circuit Court of Appeals. No First Amendment violation here because it was a student threat. A true threat is never protected by the First Amendment. So you compare this case with the earlier cases that we discussed. And those earlier cases didn't have a true threat, so it was more of a First Amendment analysis. Maybe the pistol lingo in the Fifth Circuit case, you could try to tie that to a true threat, but it wasn't as open and obvious of a true threat as this particular Ninth Circuit case. So true threats are never protected by the First Amendment. And it's certainly after Columbine and all of the other school tragedies, the courts seem to be getting some of these cases right. So in New York, we have a middle school student. He sent an instant message to a friend that included an icon with a pistol firing bullets at a person's head with the words, kill his English teacher. It's a 2008 case. Student was given 1 semester suspension, and the parents challenge on First Amendment grounds. And let's see what they argue. They argue that this speech was not a true threat. And so upholding the federal district court's decision, they grant summary judgment to the school district. Here's a Second Circuit case. Again, remember the Second Circuit was the same court that heard the douchebag case. And they felt that this really just crossed the boundary of protected First Amendment speech. And even if it wasn't a true threat under Tinker, it was reasonably foreseeable that there would be a material and substantial disruption. And they really focused on this Tinker aspect rather than the true threat with the parents were trying to focus on within their arguments. We have another Minnesota case, fairly recent case, where a student sent an instant message from his home to a classmate at school. And again, it's dealing with getting a gun and shooting students. He noted that he has access to weapons, and he really wanted to be known for something. So imagine that happening in your school. The school officials were notified. They contacted the police. The student's placed in a detention center. He's later expelled, and again, the 8th Circuit Court of Appeals upholds the district court's decision. They found that this could be considered a true threat, and they didn't even do a First Amendment analysis because true threats are not protected by the First Amendment. But I also wanted to point out the court also noted that the First Amendment did not require that they had to wait for the shootings, that's good, huh, to be carried out before disciplining the students, even under substantial disruption analysis. Now, when I teach these First Amendment off-campus cases to my aspiring principals and superintendents, when the cases don't deal with guns, but maybe more like the case dealing with herpes and you're a slut, they say, we hear about it on Monday morning and we know that there's going to be substantial disruption during the lunch period or during hall passing time. And the courts haven't always been so consistent in allowing this foreseeable disruption in some of those cases that are not involving speech that's dealing with guns and ammunition and other weapons. At the Ignite 2015 conference in San Diego, people were asking about phishing expeditions. Can you search a student's iPad if they bring the iPad to school, or can you search their cell phone if they're texting things that are inappropriate? So I wanted to include one case that recently dealt with this issue in 2012. So we have an 8th grade student posted on Facebook. She hates her school monitor. She receives a detention. So she writes some profanity on a message, and they learn about this. School officials learn that about a sexually explicit conversation later that she has with a fellow student, and they want her password. They want to read through her messages and see what she's been posting, related to the hall monitor and the sexually explicit discussion. So they read her public and her private posts on Facebook. And she has a problem with this. She says this is a violation of her First Amendment rights. Sometimes students allege privacy rights under the Fourth Amendment. They'll bring up search and seizure claims within these types of cases. And in this case, the court said they did violate her First Amendment rights because, and her Fourth Amendment rights, because it was just, the search was overbroad, and ACLU's picked up on this case and other cases to say, you know, most of the time it's problematic to, you know, ask or force a student to turn over his or her password. I'm sure if this language that they suspected, if they had reasonable suspicion that maybe the language was about blowing up the school or something a little bit more severe, it may have had a different outcome. But again, no U.S. Supreme Court decision on this type of question in a K-12 context, and I think we just need to have more cases addressing this issue with Fourth Amendment and First Amendment before we can really find a general trend with regard to these types of cases. So now I want to switch gears. We just have about 15 minutes left about teacher speech and social media. And boy, there's been a lot of current events on this particular topic, and a few court cases that are just starting to come down from courts. Now you have to remember that the federal court system is sometimes a little bit slow to respond, and we're still dealing with MySpace cases and just moving into Facebook. So these court cases always tend to lag behind really what's happening in schools. But in Pennsylvania, you'll see on the screen a teacher blog that her students were frightfully dim and whiny and utterly loathsome. In another case, one administrator referred to colleagues as cockroaches and common thieves of public money. I've taken a few other notes of either real-life cases or current events that I've read about, whether they're on CNN or other media links. In Florida, a teacher posted, "I'm super horny and I'm an A++ in bed." Another teacher in Florida said, "I'm watching the news, I'm eating dinner, when the only story about New York okaying same-sex unions came on and I almost threw up." Well, people found that offensive and complained about the teacher's post. Another one in Florida, a teacher said, "I'm fairly convinced that one of my students may be the evolutionary link between orangutans and humans." And in Tennessee, a teacher wrote, the best form of birth control would be girls displaying their big pregnant bellies publicly on Facebook," referring to her students. In New Jersey, a teacher posted, "Homosexuality is as perverted spirit that has existed from the beginning of creation." In New Jersey, a teacher wrote that she was a warden for future criminals. And then in Massachusetts, a teacher described her students as germ bags and parents as snobby and arrogant. In New York, after today, I'm thinking that the beach is a good field trip for my class. I hate their guts. And this was posted after a student had drowned. It was either in New Jersey or New York on a field trip to the beach. So she was referring to that student drowning. And in Illinois, a teacher posted a picture of a 7-year-old student in her class with Jolly Ranchers tied in her hair for her Facebook friends to mock. So needless to say, these types of posts by teachers had really created controversy among the parents and other students, if the students were old enough to realize what was going on. So in my classes, a lot of the administrators will ask me, well, what can we do? They're posting these types of comments either on Facebook or Instagram, or they're putting them on their personal blogs. Can we step in and discipline these teachers for what they're writing on their online or on their social media? And it's a difficult area to navigate right now, really, because we don't have a lot of litigation. Again, no definitive answer from the U.S. Supreme Court, but from your school law courses, especially if you took it recently and you're familiar with the Garcetti decision, and you probably, if you took it many years ago, you know about the Pickering decision, you'd probably first want to ask whether the speech that the teacher presented online, that parents now know about, whether this teacher is speaking as a private citizen or pursuant to his or her official job duties. So if the teacher is speaking as a private citizen, for example, and posts something like on Facebook or Instagram saying, medical marijuana should be legalized in Indiana, my uncle is suffering from pancreatic cancer, or same-sex unions should be legalized in X state. If a teacher writes something like that on social media, I would argue that that teacher is speaking as a private citizen, even though some parents might be offended by that, is speaking as a private citizen, and until under the Pickering balancing test, you may remember from school law, if it really causes disruption and interferes with supervisors and whatnot, that that speech is generally protected. And even under the more recent Garcetti decision, where the court asks, is the speaker or is the public employee speaking pursuant to his or her official job duties, I would argue not, that these are issues of public concern, medical marijuana, gay marriage, immigration. But I'm sure a lot of you are gritting your teeth right now as you're hearing me say this, because you can imagine maybe a teacher commenting on any three of those issues and then parents coming in to complain about that speech that was posted on the World Wide Web. But that's generally what we're seeing in courts that have addressed teachers' off-campus speech that deals with matters of public concern. Now, some of the other things that I just read you from the, case or the situations in New York where the teacher wants a student to drown. There was another teacher I didn't even read in North Carolina who called her students ghetto. I would argue that that's absolutely inappropriate, of course, and interferes absolutely with the teaching effectiveness of that teacher, especially when she ties it to students in her classroom or his classroom, would be highly problematic. I'm going to switch to just another slide. Other times I just wanted to point out that some of the speech is sexual in nature. I already kind of touched upon the political speech with gay marriage and matters of public concern, let's say immigration or medical marijuana, or maybe a teacher is posting something about ISIS. Those are more matters of public concern. But in New Jersey, we had a teacher who posted that homosexuality was a sin and that it breeds like cancer. We had a teacher actually in Indiana, Sullivan, Indiana, about a year and a half ago, post something similar. In California, we had a middle school dean who posted obscene photos and comments, obscene comments, sexual comments on Craigslist. These are difficult to navigate too. We don't have a ton of precedent to give us a lot of answers on these cases, but I would imagine the teacher will argue, I have a First Amendment right. I feel homosexuality is a sin and this is my religious belief. And then you have school officials and angry parents and probably the ACLU arguing, come on, this is connected to school. You may have gay, lesbian, bisexual teachers that you work with and students that you work with, and how can you possibly be effective in the classroom when you're posting things such as this online, or posting, highly offensive sexual commentary on Craigslist that everybody seems to know about in the school. So the last two slides dealt with speech, what teachers are posting and saying on words on social media. But at Ignite 2015 and in all the classes I teach, I get a lot of questions about pictures that are posted or actions that are made aware on Facebook or Instagram. And here we have two teachers who are out drinking. This reminds me of a real-life case out of Georgia. If any of you are from Georgia, you probably remember this recent case, but it was all over the media, so I'm going to just briefly give you the facts. We had a teacher during her summer vacation. She went to Ireland and she went to the Guinness Brewery. her friend took a picture of her with the beer in front of her and posted it on Facebook. And she also said, when I get back to Atlanta, I'm going to play Crazy Bitch Bingo. Apparently that's a game that's really hot in Atlanta. And people saw this. They found it offensive. They complained. And this teacher was forced to resign from her position, her teaching position. She later got smart and realized they probably could not have forced her to resign because this was not illegal, drinking beer in Ireland. You know, who wouldn't do that? And summer vacation, and this wasn't offensive, and this is her life as a private citizen. And she sues, and they do not give her her job back because she resigned. So it was more focused on that. But had she not resigned, and they fired her, I would argue she would probably have a viable legal claim, but we don't know. A similar case where a teacher during her summer vacation goes to a bachelorette party. She gets up on stage with a male mannequin and performs fellatio in front of the crowd, and someone records her on the phone, and it's posted online unbeknownst to her. After she finds out about it, and parents find out about it and complain to school officials, it was removed, and this did go to litigation. And in these types of cases, you know, with the speech cases that I just spoke of, in the speech cases there has to, you ask this question, is it a private citizen? Is she speaking about, or is he speaking about a matter of public concern? Was this speech made pursuant to his or her official job duties? Oftentimes with these cases, with the pictures that may not be protected under the First Amendment, may not be speech, we see some of these cases where the courts will say, well, is there a connection back to the school? And if there is a connection, did this impair the teacher's effectiveness in the classroom? That's one of the trends that we're seeing with some of these cases. So I gave you the example of the teacher drinking Guinness over the summer. The teacher up on stage during summer vacation, that teacher actually won her case because the court said even though some of your actions were unbecoming of a teacher, what you did was, you know, done during your personal time, and that was a little bit far-reaching what the court or what the school district had done in that particular case. So the teacher was successful in that second case at the bachelorette party. There have been other cases where there was an art teacher. He put on a disguise that the students could still kind of tell who he was. He would paint with his butt. He would sit and paint, and then he would take his painted butt and sit on paper, and he would create art this way. And he posted it, of course, on YouTube. And parents and students found out about it. And after this teacher left the school district, this teacher was able to settle out of court. There was a lawsuit involved. And the teacher was successful in that particular case because, again, not enough connection back to the school where it creates this, you know, disruption where it really impairs the teaching effectiveness. There's countless other cases. In Kentucky, there was a teacher, an award-winning biology teacher. I think it was biology. She taught science courses, but 10 years earlier, she had been in porn films in LA. So, of course, some of the parents found out that she had been a porn star in her previous life 10 years earlier and complained about it. And I believe her contract wasn't renewed. I don't think it was a firing. And another teacher in Florida worked on a shrimp boat where everyone was required to wear kind of skimpy bikinis to subsidize her $30,000 a year salary. Parents found out about it, that she was wearing these skimpy bikinis, and complained about it to school officials. So a lot of times in these cases, there needs to be a connection back. You really should show that it impairs the teaching effectiveness. I'm going to just highlight a few more cases. This is a real-life case out of Oregon. A teacher took a lot of prescription drugs and tried to run over her estranged husband and with the pickup truck, and she was disciplined, and she ultimately won that particular case because there just wasn't enough connection back to the school, even though her actions were illegal. And I've seen very mixed cases with this. I've seen some cases where, you know, there's an illegal DUI, and in some cases that dismissal is upheld, and in other courts it's not. So again, we're not seeing a general trend with some of these cases where the teacher's actions are illegal but not really connected to the school. I'm going to end with the last case that I did in San Diego as well, to show that a lot of times you want to consider the age of the students before you discipline the students. Now, I don't make this up. I was at the Education Law Association annual conference a few years ago, and I was sitting next to an attorney, a school board attorney, who works in the Maryland, Washington, D.C. area. And he was recounting a story where he got a call from the superintendent and said, hey, our kindergarten teacher, one of our kindergarten teachers, was in a porn magazine. There was a special issue on beaver hunting, and her husband sent in, I don't make this up, sent in a picture of his wife's private area, and parents found out about it. What do I do? And just think about what that attorney told that superintendent to do. This was a kindergarten teacher. The school board attorney said, do nothing. Do nothing. Do not create a disruption. She teaches kindergarten. How could this impair her teaching effectiveness when kindergartners don't know what beaver hunting means? So you can see it play out. Never went to litigation. But that's the trend we're seeing with some of the courts, is it needs to have a connection back to the classroom, and it needs to really impair the teacher's effectiveness. So I see that I'm at 4:15, and I know we wanted to reserve 15 minutes for questions, so I'd love to open it up to questions about any of these issues, whether it's students off campus, online speech, or teacher conduct, which we just discussed.
Suzanne, we do have some questions, and any that we don't get to, we'll respond to after the broadcast by email.
Great.
The first question is about the difference in public and private schools. It seems that there's less recourse for the public schools. I work in a private school, and we'd absolutely discipline each of these issues. Is there a difference?
There is a huge difference. So that's an excellent question. So under the 14th Amendment of the U.S. Constitution, we have the Due Process Clause. And before you fire a public school teacher, those teachers have certain due process rights, which would not apply in the private school context generally because there's no state action involved. So that's why in the private schools you'll read, you can Google right now and you'll see private schools even dismissing teachers who are pregnant out of wedlock, which couldn't happen in a public school, or gay teachers, which likely shouldn't happen in a public school, or teachers with these pictures with alcoholic beverages in their hand. So there is much more leeway for private schools to discipline or fire teachers than there would be in a public school setting. Now, I have seen some policies in private schools, certainly some really progressive private schools in the San Francisco Bay Area and Madison, Wisconsin, and different, I would argue, maybe more liberal private schools, where they do grant these types of protections to their private school teachers, but they don't have to. So that is a great question. I'm glad it was asked, but there's absolutely a distinction between private school teachers and public school teachers.
Next question. Often the situations like the ones you described disrupt the administrator's time, preventing him or her from attending to duties. How is substantial disruption defined?
Oh, that is a great question, and I wish I had a great answer, and I don't. You just have to read all of these cases, and there are many, that, even more, that don't deal with off-campus speech, just cases that cause a material and substantial disruption in the school, maybe a graduation speech or an art project that someone hangs in the classroom that school officials would argue that creates a material and substantial disruption. It's very subjective. And I was reading a case recently where one court found the fact that a teacher had to take a short leave of absence from what was written about her on Facebook by another student. that was a material and substantial disruption on the administration, because they had to find a substitute teacher to cover this teacher for the days that she needed to, I even think she had to speak with some type of psychologist about what was written about her online, and that was a substantial disruption according to that court. Other courts haven't taken that same approach, where that's not, teacher missing a few days is not a material and substantial disruption. Certainly I would argue a huge fight that breaks out after school, on school grounds, or during the lunch period, or during passing period, would be substantial enough to be called, a disruption in that case. But it is very subjective. I recently have been reading all these Confederate flag cases. There's a recent case out of South Carolina, went to a circuit court of appeals, where a student wore several different Confederate flag t-shirts to school. She wasn't allowed to do so, but I was reading other earlier Confederate flag cases from around the country, and how they found disruption really varied from school district to school district, and I found that very surprising. There isn't a clear-cut answer to help school officials figure out what is a substantial disruption.
And that sort of leads into the next question. Since the courts have not been consistent in their rulings, how can school officials, school leaders, proceed when students or parents come to them for assistance, or when they confront an issue like one of the ones that you've addressed today?
Yeah, that's another great question. Now, if you are in, let's say, the Fifth Circuit, and you're within that jurisdiction, and let's say a teacher would come to you and say, discipline this student for this rap song or for whatever was written on Instagram or Facebook. You could say, oh, well, look here, we have from the Fifth Circuit Court of Appeals a brand new decision that says X, Y, Z. So if you're in one of the jurisdictions that a court has addressed this at the Circuit Court of Appeals level, or even federal district court, or even state court, and it's recent, and you could say, look, I can't, my hands are tied in this particular instance, whether it's teachers or students, that can be helpful. But the general trend is with students, I know I only had one slide from the Fourth Circuit Court of Appeals where, the student said that the other student had herpes and was a slut. Now you remember from that case, they were allowed to discipline that student. The school district won in that case. So, in a lot of those types of bullying and harassment, you've got, guidance from the U.S. Department of Education, recent guidance on bullying and harassing kids with disabilities, gay students. Even before that, just general education population. You have guidance from the Department of Ed and the U.S. Department of Justice. You have plenty of cases on your side to say, I have to step in and address this type of peer sexual harassment under Title IX or even under our state's bullying law. The cyber speech, the social media speech, is a little bit more tricky because you have to have the connection back to the school and then the substantial disruption. But there are plenty of cases dealing with cyberbullying where you are allowed to step in if it's student-to-student bullying. Where we see it be a little bit more difficult for you to discipline as a principal or school administrator is the speech of the cyber speech that's attacking teachers. So I hope that answers your question. But feel free to send a follow-up and I can continue talking.
I think we have about 3 more questions that we have time
Okay.
for, and I'm going to collapse a bunch of questions about private devices and school-owned devices. What is there a difference in the rights that a school has to search or request the password for devices based on whether they're school-owned or privately owned?
Oh, that's a great question, too. So I have a student who's writing a dissertation on this right now because there just isn't a lot of peer-reviewed information out on this topic. And there are very, very few court cases that address this topic, so we're kind of in uncharted territory right now. I want to answer something I should have covered while I was going through the PowerPoint that I didn't, that relates to searching students, let's say their cell phones or even their school district issued iPads if you have a one-to-one initiative at your school. So let's say in class a teacher is teaching a math lesson and you have a let's say no cell phone policy. I'll just use the cell phone example. You have a no cell phone policy, and that teacher sees a student texting another student, and confiscates that cell phone and argues, we have a no cell phone policy. According to the policy, we keep this cell phone until your parent comes in and meets with the principal, or whatever the policy might be. But as she's picking up the cell phone, she sees a text message that says, and this is a true life case actually, I'll tell you about it, where she picks up the cell phone and the cell phone says, bring me a fucking tampon. I swear to God, this is a true case. And the teacher thinks, oh, this student is talking about a joint. Bring me an effing tampon. So maybe in that situation, or if there's a picture of the student's boyfriend naked and the kids are sexting, then perhaps school officials would have individualized reasonable suspicion to continue searching that device. But let's change the facts, and if the teacher picks up the cell phone and there's nothing on the screen, you can't find anything, but school officials start searching, that would be problematic. But if you have individualized reasonable suspicion to search, let's say, a cell phone that's on a student desk, or even if you're doing a math lesson and everybody has their iPads out and that student seems to be fooling around and doing other things, if you have individualized reasonable suspicion to search what that student is doing, I would argue, you look at Fourth Amendment case law dealing with search and seizure that allows searches if those searches are reasonable at their inception and reasonable in scope.
Okay, a question about resources. There have been several of them, but kind of combining them together. What's a good resource for school leaders to use, or a subscription, or a website that people can go to keep up with the kind of information that you're talking about?
Well, one really good free legal resource is the National School Boards Association. They're legal clips you can Google. You can sign up for those. They'll come into your email, your inbox every Thursday, and they'll highlight some of the cases that are going on. A lot of times they won't give you definitive answers. They just summarize the cases. There's another group called the Practical Education Legal Team, and I think if you Google them, you should be able to find them. They'll send you every Tuesday a free case that summarizes a real-life case that came down. If you can't find it on Google, let me know, and I can put you in touch. The man who runs it out of Washington, D.C., his name is Ed Darden, D-A-R-D-E-N, and he can sign you up for those Tuesday summaries of those cases, and it tells you lessons for principals. I write the monthly column for Principal Leadership Magazine, and I always have a legal 1,500 to 2,000 word. We address off-campus speech in one of the columns, but we do all kinds of different things, and we have recommendations. Oftentimes I team up with an attorney or other professor in those articles with expertise in that area. And then the Education Law Association is a great resource. I don't remember exactly what the fee is to join the Education Law Association. I think it's maybe $500 a year. They have an annual conference every year. Last year it was in San Diego. This upcoming year is going to be in Cleveland. And even if you can't get off of school and afford that conference, they have all kinds of really great publications that are pretty inexpensive. They have the Principal's Legal Handbook and all sorts of monographs on these timely topics.
One quick answer on the last question we have time to deal with today, and we'll have to answer the others by email. What about teachers' First Amendment rights that post negative things about school leadership and social media?
That's a great question. So there was a decision that came down from the U.S. Supreme Court that had nothing to do with schools. It's the Garcetti opinion. It had to deal with the district attorney, but it applies to schools because it's dealing with a public employee. And in that case, the court said, when you're analyzing First Amendment rights of public employee speech, you want to ask if that speech was made pursuant to the teachers or the public employees' official job duties. And if that speech, if you can show that that link is found pursuant, and I've read a lot of cases since the Garcetti decision within the K-12 school context, and I'll tell you the majority of the time those teachers lose their cases against the school district who, you know, when they're disciplining the teacher for being critical of the school, if you can show that there's a link to the teacher's official job duties. So let me give you just a very quick example. Let's imagine there's a French teacher. I'm a former high school French teacher, and I really was, so I'm just using this as an example, where they're going to cut junior high foreign language and elementary school foreign language. So let's say that I write a letter to the editor and I post on Facebook, what is this crazy superintendent and school board thinking? Don't you know the research that it is so important to have foreign language in these early grades? And I write some pretty offensive things about my superintendent and the school board. That, I would argue, is speech. You know, could be speech as a public concern, about a public concern, but I would also argue that speech pursuant to my official job duties, and I think there would be a good chance that I could be disciplined for that type of speech.
Thank you, Suzanne. That's all the time we have, but I would like very much to encourage each of you to record Suzanne's contact information so that you can communicate directly with her. And I'm guessing you would welcome that, Suzanne?
Absolutely.
And also, I'd like to invite you to come learn more with us next year in Orlando at Ignite 16. You see the information there on the screen for that. The most asked question today was, how can I get the PowerPoint slides? If you will go to nassp.org/webinars video, you'll be able to access the slides from today's presentation. I'd like to thank you for joining us, and